More than a month ago, in a landmark ruling, the Supreme Court reshaped the contours of the governor and president's power by fixing timelines for them to decide on bills cleared by the state legislature. Now, the central government, through a presidential reference, has sought clarification or an opinion from the top court on whether such deadlines can be fixed judicially. This reference has been made under Article 143, Subclause 1 of the Constitution, and it poses 14 questions to the Supreme Court. Besides, the reference seeks clarity on some other contentious points of debate that have emerged from the same judgment. One of them is with regard to the scope of Supreme Court's extraordinary power under Article 142 of the Constitution. Under this provision, the top court can pass orders to secure complete justice. The judgment on which the presidential reference raises doubt had declared Tamil Nadu Governor R.N. Ravi's refusal to assent 10 state bills as unconstitutional. The genesis of the judgment lay in the standoff between the governor and Tamil Nadu government over bills that were pending before the former for his approval. In the process, the court had underlined time-bound guidelines under Articles 200 and 201. While Article 200 deals with the governor's powers to give assent to a state bill, Article 201 relates to similar powers that can be exercised by the president. Under Article 200, on presentation of a bill passed by an assembly, a governor is required to grant assent as soon as possible or return the bill excluding money bills for reconsideration by the House. The provision specifically says that the governor shall not withhold assent when the bill, after reconsideration, is sent back to him or her. The governor can refer the bill in case it is in conflict with the central legislation to the president, who then, under Article 201, has the mandate to assent or withhold. SC has used its powers under Article 142 to declare that the 10 bills passed by the Tamil Nadu Assembly after reconsideration and then referred by the government to the president were deemed to be approved. This ruling took a dim view of the governor's obstructionist approach in the matter, while observing that his inaction could potentially cause an executive paralysis in the state. It had said that the governor could not have referred the bills to the president in the second round when they were sent back to him after reconsideration by the state legislature. The verdict then became a flashpoint between the judiciary and Bharatiya Janata Party ruled central government, with Vice President Jagdeep Dhankar on several occasions describing it as judicial overreach. Importantly, instead of invoking the review jurisdiction of the Supreme Court, which allows a contesting party to ask the court to reconsider its decision, the government has chosen the route of presidential reference. Under Article 143, Subclause 1 of the Constitution, the President can seek clarity on myriad constitutional issues. It's a mechanism for the centre to seek advisory through the President when there is doubt on any question of law or fact. Pendency of several petitions on disputes between various opposition-ruled states and their respective governors before the top court has necessitated the reference, which also raises an eyebrow over states resorting to Article 32 instead of Article 131 to file these cases in the Supreme Court. Article 32 is a provision used to approach Supreme Court and High Courts for enforcement of fundamental rights, whereas Article 131 grants the top court original jurisdiction to hear disputes between centre and state governments. On deadlines for governor and president, the reference wants to understand whether the SC ruling in Tamil Nadu Vs Governor case would count as a justiciable action, particularly as the Constitution is silent on the matter. With regard to the extent of the use of Article 142 of the Constitution, the reference wants clarity on whether the provision can be used by the Supreme Court to substitute constitutional powers and orders of the President or Governor. The reference also touches upon another point of friction between judiciary and executive arising out of the judgment. In the decision, the Supreme Court had suggested that in case of a conflict between a central law and state legislation, the President can seek advice from the top court through a reference under Article 143. The reference wants SC to clarify if such a direction is valid in terms of the constitutional scheme governing the powers of the President. The reference that has been made to the Supreme Court will be looked into by Chief Justice of India B.R. Gavai, who would then go on to constitute a 5-judges bench to answer them. The court may also decline to offer an opinion if the referred questions are deemed purely political or socio-economic and lack constitutional relevance. To be sure, presidential reference under Article 143, Subclause 1 is made under the advisory jurisdiction of the Supreme Court. Hence, any decision on this reference is not legally binding. However, it can serve as a guiding force in similar disputes arising in future, and it may also influence the Parliament to consider legislative reforms, codify procedures and timelines for constitutional heads to minimize judicial intervention in executive decisions.